Business or compensation? Can I call Daniel Monestier-Carlus, Mikhail Ambrosio, Eric Rance, Martine Verdier, and the moderator will be Alexandre Regniault. So hello everybody, thank you Guy. So trials, have they become a business? This is rather provoking, this question. Already, for several years, we've been talking about judicialization of healthcare. We are seeing trials, litigation. People are suing health organizations, suing against health products, and it's all for good reasons. But there are many challenges around these judicial actions, and to talk about that, we've invited several speakers, and we'd like to thank them for coming. Mr. Eric Rance, President of the National Office for Medical Accident Compensation, Director. Mrs. Danielle Monestier-Carlus, who is President, I believe, of the National Commission of Medical Experts on Health. Martine Verdier, who's an attorney at law here in Lyon and defends many victims. And Michael Ambrosio, from Covington and Burling, who is involved in many trials in the interests of industrialists and, of course, in the United States. So let's see the film that introduces the debate. Litigation, business or compensation? Paris, 2062, as Caroline, 29 years old, leaves the hospital. A lawyer stops her saying, "You just had your appendix out. Do you have a scar? In my opinion, you should sue. You'll be better off for it." This somber scenario of excessive litigation is widely feared in the health sector. It's true that the American example is quite frightening. Everything there reaches the courts in business mode. We've all heard examples of the astronomical levels of compensation obtained by certain victims. What is less well known is that since lawyers in the US are paid a commission on the amount of the compensation payout, they only accept to defend patients who have suffered major injuries, meaning above $50,000 or 44,000 euros. Did you have to have your thumb amputated after contracting a nosocomial infection in hospital? That's not profitable enough. What is the current situation in France? Since 2009, the ONIAM has been managing an alternative dispute resolution process, and there are no costly legal actions for victims who have free and rapid access to a conciliation system. After having compensated the victims, the ONIAM can then seek redress from the person responsible for the injury, if there is one. The other side of the coin is that given the ease of access, the French system can generate a windfall effect that is sometimes exploited by victims' associations in all good faith. You took mediator but suffered no harm. You can always claim that you're suffering from anxiety. As regards the judicialization of healthcare, the new great unknown stems from the door opened by the law of the 26th of January 2016, introducing class action suits for victims of medical errors. The result may be the same type of multiplication of class action suits as we see in the US. So this is a film that will lead to reactions from our speakers. But to begin with, let's just remember that in a legal context, judges are not all armed to determine who is liable, who is responsible. So they call on experts. They call on experts who are judicial experts, who are experts in the courts, different types of courts, or administrative experts. So these experts, they need to be paid. So Mrs. Monestier-Carlus, so a judicial expert is not very well paid, as far as I understand, and it takes a lot of time. You've got to study files, you've got to draft a report, a big report sometimes, because the other lawyers request this report, so this requires time. So my question is as follows. How do you attract the right experts to this judicial expertise activity? So very good doctors who probably have other things to do with their patients and with industrialists. how do you get the best to become experts? Well, we respect them. That's the first thing that we have to do. Judicial expertise, it's very well coordinated. It's not a function, it's not a job. It's supervised by legal text. The status of legal expert has been very well defined. There are rights involved. For example, if a doctor is acting as an expert for a court of appeal or another court, they are paid. We'll talk about that at the end. But they have duties, many duties, and it's true that France supervises this extensively, but they have to guarantee impartiality and independence and objectivity of the expert's report. So no real problems in terms of quality when it comes to judicial experts. The conditions are there to supervise things properly. Yes. Basically, when you look at the percentage of good legal experts, the sorting is carried out by people who sign up for it. You can't be an expert for life, as in the past. It was a kind of a business card that people have. I'm an expert. You didn't do this kind of work because you didn't have enough time. You know that doctors, they have a lot of work to do. It's very time-consuming what they do. So now there's a systematical renewal with the periodic examinations. Yes, every 5 years they have to be re-examined. Every year, the list of training, procedural training and professional training, and the list of assignments carried out has to be sent in. Okay, we'll come back to that. Thank you for that first enlightening piece of information. Martine Verdier, you defend victims. Perhaps you could say a few words, shed some light on this question of judicial expertise. And going back to the theme of the day, what about money and healthcare? Can we, the three lawyers around the table here, is it all about business defending victims? Are there market shares to be gained? Do you have competitors, other lawyers, other associations? How do you position yourselves in relation to this? And we can imagine that there may be difficult decisions to be taken to keep, to maintain the interests of your customers who are patients. Yes. First of all, I'd like to say that taking a lawyer when you're a victim of medical act or a medication is essential. I'm not just preaching for my own church here. I think it's essential. It's indispensable to take an advisor so that you are enlightened in this complex procedure. It's complex for two reasons. The legal technique, first of all, is complicated. There are rules that are very complicated for anybody who hasn't studied law. It's also complex from a medical point of view. You need a lawyer. It's a judicial procedure. Or even whether it's an amiable procedure, and my colleague is familiar with this, even if it's an amiable procedure, the victims who go and look for compensation can unfortunately come up against agreement protocols that are not enough, or they sometimes renounce their entitlements faced with the industrialist. This was the case with mediator. So let's go to the subject, lawyers of victims, money and healthcare. Any lawyer is paid, and we find it a good cause. We're in a field where it's all about compensations. What you're trying to find is recognition of responsibility for the victim. It's more than this, it's compensation for the damages caused. When we talk about compensation, obviously we talk about money, and we talk about lawyers, you talk about fees. These fees are supervised by an agreement that you have to sign before the procedure starts. It's an agreement that cannot just be based on results. That's forbidden in France. That's very important. It means that you don't have to have 100% success. However, in France, you can agree to a minimum price that depends on different parameters that you agree to with the client and a results-based fee. And this is where you have to be careful if you're a victim. So there are lawyers who are the results fees have to be in line with the complexity of the procedure, and they mustn't go beyond a certain percentage. What percentage are you talking about? Well, the percentages are different in the provinces, in Paris. They also depend on how complex the trial is. I think in France you might consider reasonably that it's between 8 and 10%. That's reasonable. That's considered reasonable. When you go up to 25%, already the conditions need to be negotiated. And if it goes up to 50%, then that's outside of what is recommended by the Council of Discipline. But these results, just to go back to what we were saying beforehand, it's added to a set fee, time spent, yes. The work of the lawyer, time spent, the work of the secretary, and then there are the results. Now, of course, it's very important to be reasonable about the results fee, and that's why the percentage has to be talked about. It's the client that contributes to that. If you win your trial, you're really compensating real damages. Now, you've got to look at where the fault is. The client will be remunerating you for a minimum amount. And if you win the trial, the client is being compensated and is expecting damages. So it has to be measured in terms of what the lawyer does so that it's not a business. And that is a problem, and I think that's what we'll be talking about. It's about group action, the way you federate files, cases, and the money in relation to the results. Do things go badly sometimes? Do clients sometimes dispute the judicial results and the application of the fees agreement? They say, well, that's not what I understood, it's too high, and then new discussions are opened even when you had the agreement to begin with. Well, it's like any kind of contract, really. In marriage, if you plan ahead for divorce, there are less difficulties. When the agreement is well explained, when the client has understood the percentage that is planned, I think there is no reason for there to be a discussion afterwards. However, the lawyer also needs to show transparent behavior. That's all about ethics. It's something that should be in the agreement. 10% of 1 million euros is not 10% of 100 euros. So the client needs to understand this notion of percentage, and the lawyer needs to be able to assess what is fair, what is acceptable when it comes to signing the fees agreement. This is the problem of, having competent lawyers who are ethical. Mike, the percentage 12%, that must make you smile from the American point of view. Can you tell us a little bit about how things go with the lawyers that you work with who are defending patients? Because we're hearing terrible figures in Europe, but we're also hearing things that are wrong. How do you go about things when you're defending industrialists?
First, the numbers that you mentioned were, in fact, heartening to me. I think most lawyers in the U.S. representing claimants make a minimum of 33% of the ultimate, and in some states it's 40%. Those of you who have visited the United States probably can't turn on the television without seeing advertisements for lawyers. Did you take this drug? Please, did you develop this disease? Please call. We have a very vibrant First Amendment of free speech, and the courts have ruled that the plaintiff lawyers can advertise for these kinds of claims.
So the ambulance chasing episode that we saw on the film, it's not just fiction, it does exist.
It's not only does it exist, it's very refined. And it is, to answer your initial question, is it a business? It is absolutely a business. Most of the best plaintiff lawyers in the United States, I would say the top 100, 150 of them have private jets that they fly around to do their cases in. They own them themselves. So it's at a level that is beyond what you envision here. In fact, the system sounds just perfect.
Private jets, ça fait rêver.
sais pas si c'est le jet qui fait rêver, mais en tous les cas, les pourcentages chez
Whether it's the jet, but the percentages in France are examined by a council of discipline, so we can't change them.
By state, but it's principally 33 or 40%, and no one ever looks at it again. The one thing that's different, I think, in the U.S., we've seen the lawsuits against the healthcare providers, the doctors, the hospitals, the nurses, tend to trail off a bit. There's been state-level reform in a lot of states that require cases to go before a medical panel before you can sue, or there's a requirement that there's an independent expert attest that there's been some breach of the standard of care, and that has really depressed the number of lawsuits against the medical providers. What has filled the gap has been lawsuits against the manufacturers, against the pharmaceutical companies, the medical device manufacturers. In fact, 30% of the lawsuits in federal court are lawsuits against life sciences companies in the entire country. It is a massive, massive amount. And one thing on the film I would say is they gave the €50,000 or $50,000 limit. What we've seen as the plaintiffs' lawyers have gotten more efficient in collecting claims and aggregating them, that they'll take less and less per average case. I just did a litigation where we ultimately settled it on average 6,000 claims for about $3,000 a case. Now, that's a lot, ends up being about $20 million, but they were able to do it very efficiently and take smaller claims, and that was, I think that's the wave of the future.
D'accord. Très bien, on y reviendra. Alors, je vais me tourner vers Monsieur.
So we'll come back to that, and I'm going to talk to Mr. Rance with a more general question. In France, we've had this system since 2002, 2003 that was quite exceptional, and thanks to the ONIAM, it makes it possible to reach compensation when there was not necessarily any type of malpractice on behalf of the doctor or the hospital. This was after many years of debate, and it's led to a healthier process, because there were lots of cases that came to court that weren't necessarily founded. So we want to avoid these types of cases coming to the court. And so, Mr. Rance, with 13 years of experience, can you say if this has been a success and if any trials have been avoided, and were these cases solved to the satisfaction of the victims? Yes, thank you. Just a quick word about the theme of the round table and the video that was shown. I was told that I could be very honest in what I'm saying, so I will be. I don't know anyone. It's been 5 years that I've been at the head at the ONIAM. I don't know if people go to the hospital just to look for compensation. So I challenge anyone to find that type of people. Yes, we can have some little problems, but people don't really raise suit when there are no reasons to do so. I think that they want compensation if there have been damages. And all the surveys that have been done in Europe, people want to know what happened. They don't just want financial compensation. They want to understand the mistake. And sometimes they're satisfied with understanding and don't necessarily want financial compensation. So this process that we set up in 2002 has a twofold goal. Firstly, we want to create the possibility of compensating for a medical accident where there was no fault through the system of national solidarity. And this is a good thing, because up until now we've had to find a fault on behalf of the doctor. So anyone who's had anaphylactic shock after anesthesia, when everyone did their job properly and there were no predispositions, can be compensated for by this national fund if they've reached the right level of seriousness of injury. So there's a good reason for this. Another reason for finding compensation, which is good for the medical sector, all parties can be heard, but the procedure is not public. It's not traumatic for the doctor or the medical professionals. That doesn't discredit the doctor or the hospital, as can be the case during a trial. That's the first interest. And then secondly, it's faster than the then litigation, and thirdly, the expertise costs are also paid for by the National Solidarity Fund. So to answer your question, in 2003, 2004, 2005, 25% of serious medical accidents were resolved through conciliation and compensation, and today more than 50% are being solved in this way. So I think that we can give an answer saying that we have found a good solution. So to come back to the fact that you said this is a non-traumatic experience, and I'd like to come back to what was said by Ms. Verdier. You talked about all the different advantages, the fact that there wasn't a lawyer necessary, because for some amounts of compensation, you need to have lawyers involved. But in practice, the person who has been injured, who may be ill, and is at the first level of the system in front of the commission, they are in this big meeting room with a dozen people around the table. It can be quite daunting because the commission comprises people with different types of qualifications. Is the patient not intimidated if they don't have someone on their side? And don't you have some feedback that sometimes they feel that they're on trial in front of all of these experts? So I go to 2 commissions per month, and it is very impressive for the patients, and it can be positive to have support. It could be a lawyer, it could be an association, and I would say that it can also be important to be supported. The victim, we do as much as we can to make sure that we support them and that the situation is calm. All I would say is that the lawyer has to be specialized in health law. In my opinion, I think this is vital. Yes, everyone's nodding their head, they agree. Sometimes a general lawyer who's come to help the person sometimes does not help the victim at all, so it's better to have a health specialist. So Mike, to come back to the American system, is it true what we saw in the film, under 50,000 euros, lawyers aren't really interested in bringing things to trial?
I said a moment ago, certainly for individual cases of potential medical malpractice, someone comes out of the hospital, an individual case, it's very difficult to get a lawyer to represent you for that amount. And we have no-fault system. Other than with vaccines, we have the vaccine no-fault system, which sounds very similar, but for pharmaceuticals, for medical devices, and for medical care, there's not a no-fault system. Where the lawyers will get involved is when they can aggregate enough claims to make it worth their while. And we have a very elaborate system in place now using advertising. One of the most prominent plaintiffs' lawyers in the U.S. uses this phrase, and I'll share it with you. And forgive me, the translators, because this may not translate very well, but he says in a very folksy way, there are 2 types of lawyers. There's the chicken catchers and the chicken pluckers. He fashions himself to be a chicken plucker, which means he's the one who takes the case to trial and plucks the money away from the pharmaceutical company. But there's a vast, elaborate group of lawyers who do very little else but advertise to collect those claims and build a big mass of actions. And sometimes the individual value is not very high, and sometimes buried in those, sometimes in very high percentages, are claims that have no merit. They didn't actually take the medicine. They took the medicine but had a very short case. And that is one of the difficulties that we face when some of my actions have 10,000 cases, 15,000 cases, just sorting through what is the garbage and what is an actionable claim can take a huge amount of money.
D'accord. Une réaction, Maître Verdier?
Mrs. Verdier, it makes me dream about the system on the other side of the ocean. I had our doctor this morning who went to London, who really interested me, and we work in a completely different way. We're not trying to
to take the feathers off the chicken, and we have no direct interest in doing that. We have a more individual approach, but this is the basis of the French system, which is a completely different system. We're not a common law country. We're a country where each individual has to prove the damages that they have suffered, that they're claiming compensation for. And so with this new law on class actions, that's going to change things. The application decree is only coming out in September, and that will give rise to other difficulties for the lawyers who will have to intervene within these class actions, these French-style class actions. They have nothing to do with the American ones. So before we start talking about class action, I'd like to come back to experts and to make the connection with the business, with the expertise as a business. Experts in France, as opposed to the American system, they're not the experts appointed by each party. They're independent experts appointed by the judge. And there aren't really any selection criteria on the financial interest because the mission will be determined on a very homogeneous way by the judge. But they can accept or refuse as many of these assignments or missions as they like. So Madame Monestier-Carlus, when you see a legal expert, a doctor who's doing nothing but that, dozens of these types of assignments per year, can we still consider this doctor to be a good expert and a good doctor? Because a good expert has to be a good doctor. If they're spending more time with their patients, that's not a bad thing because they are experts. But is the opposite true? So I'd like to talk about the experts. It's rather like the hay carts. If you fill a cart with hay, some continue to work because they're strong and others crumble, the axle breaks. That's a bit of a broke. There are some experts that can do a lot of work, who can bear quite a heavy workload, and others who are quickly overrun. So I'm talking about legal experts here, those who are appointed by the courts, the administrative courts. And I'm not talking about people who do the conciliation expertise. There are some who do this. This is another business. I'm not criticizing this, but it's another business. And then there are other experts that work for insurance companies that work exclusively for insurance companies. They can also work for the courts. Yes? Isn't there a conflict there? That is, there could be a conflict of interest. Yes, and we can come back to that later. But judges are quite vigilant about this, and they have really cleaned house. Yes, there was some house cleaning that was required. Well, there are still some people who are doing a bit of both. Well, normally things go well, but there can always be a black sheep. But a legal expert, can they be trusted to judge a conflict of interest? Let's talk about a case, as was mentioned in the previous roundtables, with a doctor who's collaborating with industry, that's legitimate, working on the development of products, and then the trial the patient will challenge a medical device or a drug, and then they realize that the expert has worked for a pharmaceutical company. Isn't that a problem? Well, it used a big pen. They were writing with a big pen that was marked with the name of the pharmaceutical company. Well, I'm not sure about the pen, if that leads to a conflict of interest, but in any case, the experts, the Association of Legal Experts, they try to ensure that the experts within their associations are competent ones. And they do a lot of awareness raising, but yes, every now and then there are some complaints that come up, and they come before the courts, complaints about these experts. Well, maybe we also need to set the cursor at the right level. It's not because an expert works with the medical industry that they necessarily have some kind of interest or a conflict of interest with the product. So we have to be careful about that. Yes, well, you have to be extremely prudent about this type of thing. If we've worked for a specific industry, if it was 30 years in the past, that might not be a problem. A lot of legal experts are quite old. Young doctors don't really accept to act as experts. They don't have the time. The young doctor we saw on Wednesdays, he doesn't want to be a legal expert. He wants to take care of his kids. Maybe when he's older, he'll do this. Well, let's ask him. I think his wife is very nice, and he could negotiate something. Well, it's a problem if young doctors don't want to be medical experts. Well, it's true that it is very time-consuming, and there's the problem of remuneration. It's defined by the magistrate, by the judge. They can set their fees, but it's really the judge that decides. They accept or they don't accept the fees that the expert requests.
Experts make.
Ah, combien c'est rémunéré une mission d'expertise judiciaire? Ouais.
Pour un médecin,
For a doctor, it depends on the type of doctor, on how well known they are. The judge will take all of this into account. If it's someone working in a big hospital, a major hospital who's very well known, they might get higher fees. The room is reacting. They're not very young, but they're very well known, apparently, in the room. If it's the more discreet expert, but very recognized for their expertise. Wait, you're saying that they're all on lists? The judge will change the fees according to how respected they are? No, but there are habits, customs. That means that in outside of Paris, they're not as well paid as they are in Paris. It's true for lawyers also. I can confirm that. You earn more over time. You're wiser. You gain in terms of wisdom over the years. How much? They want to know how much. They want some figures. So the judges are very prudent, and they have established reference guides. They're very prudent. Their references, it's not a real defined list. Well, you can find them all on the web. So there are guidelines, but nothing's set in stone. We wanted to be as transparent as possible. We wanted to understand how it was decided. So go look on Canal CHAM, and tomorrow we'll give the list of payment for the legal experts. So we want the figures. They're not letting us move on. Maybe our American colleague could give his figures. For physical damage between 600 and 1,000 euros per hour? That's a problem for the quality of the expertise. Yes, it's difficult to do legal expertise. And for medical responsibility, between 1,000 and 2,000 euros, you could ask for more. You have to justify it. It depends on the number of operations. If you have to study all the elements, that's not very well paid, given the meetings and everything.
For the whole assignment.
No, it's for the whole assignment.
Come to the U.S.
don't worry.
On average, the really well-respected major institution physicians will make anywhere between $750 and $100 or $1,000 per hour. And in a given case, they can make anywhere from $100,000 to, I've seen one doctor make $700,000 in one litigation.
Alors en France, vous expliquez ça au CNOM, vous risquez la radiation tout de suite. Hein.
If you talk about that in France, you could be disbarred immediately. So let's talk about something that's topical, the class actions that are now possible in France. The decree was published 2 days ago, and so I'm going to start by questioning you, Mike. Class actions against drugs or medical devices, I've understood that it's not going so well, and not since the last few years, and since Vioxx, there have been very few because it's very difficult to collect all of the information, the fault of the product at the scale of a group of patients, because the trial will require individual expertise of all patients. Do you think that French have been right to introduce this new mechanism into their law?
Things we have in the United States to export, our class action system is not very high on the list. I will say that. You're right. When it comes to personal injury class actions, it's very difficult in the United States to get a class certified because, as you say, the individual issues.
La certification d'une classe, hein, c'est donc le fait de déterminer.
The certification of a class is to have a homogeneous group of patients, which means that the class action can be receivable.
Where you still see class actions against the life science industry are so-called economic class actions, where there's a class action claiming that the company did not communicate the risks of the medicine appropriately, and therefore I paid too much money. If you had told me Vioxx would give me heart attacks, I would have only paid $50 versus $100. And there's been great efforts to try to certify classes in that area. It's still very difficult, but that is the one area against the life sciences industry where you still see class actions, economic loss class actions. Now, they're all bunk, but nevertheless, there's a lot of action still there.
Ah, il y en a quand même encore, hein, sur des produits de santé ou des...
There are still actions against healthcare products, devices. There are still class actions underway in the U.S. It's not dead the way we've heard. It's an instrument that's still used legally.
For economic loss. For personal injury, it is, but for economic loss, it is not.
D'accord, d'accord. Alors, inspiré par cet historique, alors vous savez que les...
Now, you know that the legislative work took a long time because the legislators' goal was to, above all, avoid any problems, American-style problems. You might be happy to hear that. That was a huge prejudice that the French legislator had. They felt that the public authorities and certain men and women thought that they were answering a need. It was something that was politically circulating a lot in France, but it was very chaotic progress because they didn't want it to look like what existed in the U.S. because all of the money was absorbed by the lawyers and nothing was given to the victims, in their opinion. So there was a group action in healthcare that's just been introduced in France. Now, Madame Verdier, you who represent groups who are suing against a drug, are you going to use this for your customers? Do you think for your clients? Do you think it's a good thing? And I would also like to ask you, this instrument works with associations who have a monopoly, so you're going to have to work hand in hand with associations in France. Do you think it's a good idea or it's useless? Well, I wasn't favorable to this class action, given the system that we have today in France, because it's going to, I think, aggravate the victim's situation rather than improve it. We're in a system of law today in France where, in terms of healthcare products, the victim can choose if it's a healthcare product that's before 1985, which was the European directive on defective products. They can engage the liability in terms of a fault of the institution. And then the French system means that the victim who receives damages must establish a cause between these damages and an actual fault of the producer, which of course is fairly complicated to establish. You can imagine that the producer or manufacturer will do everything to hide any faults that he has committed. The second system is the law on defective products, which is a very unfavorable law to the victims due to lead times which are very limited. So it's 3 years maximum after you're informed of the prejudice. And the victim must establish the defect of the product, which is even more complicated for victims because although studies have been published, you can imagine that the controlling authorities would not authorize this product on the market. So we're in a system that's a bit of a vicious cycle because it's very difficult for the victims to prove these things. That's the French system that existed up until now prior to class action, yes, and it won't change. Now, if you're alone, you will come up against this probatory system, which will be a legal debate between you and the company. If you are in a class action, you will be 80, 120, 150 individuals trying to establish this same fault and you will have this same difficulty. Now, we may think from the start that seen this way, class action would be favorable because you can federate resources to try to find a single fault. Unfortunately, we are in an area where, by nature, the problem of the victim is an individual problem. In other words, it's not because, let me take an example, a recent example that we had with a lot of media coverage in France. Mediator. It's not because Servier put Mediator on the market and it was a defective product and it developed cardiac problems that anyone who has a minimum cardiac leak has necessarily a leak that's linked to the fact that they took Mediator. So that's the link of the probability of the damages to the product. So what will the class action do? It will allow you to establish, perhaps, that the company, Servier, committed a fault, but it won't allow you to establish that Mr. Smith or Mrs. Smith have personal damages linked to this fault committed by the manufacturer. So we're in a system where to federate victims and to imagine that they might be able to have a guarantee of less complicated legal proceedings, they'll actually be in a much more complicated system because they will have to sign up for this class action, and you have a limited deadline. So otherwise, you'll be excluded from the class, the group. And then we don't know what will happen for the victims who weren't declared immediately, but who should have declared themselves because they're unaware of these damages. So these are many legal issues that have arisen in France before the introduction of class action, and it seems that they would be more in the interest of the industrialists than the victims. I didn't hear the manufacturers asking for this class action, so I don't understand. Well, it's like this law on defective products. When the law was first transposed into France after the European directive, we said to the victims, this is going to be huge progress for you. You will no longer have to justify the fault. You will only have to justify the defective product. Well, actually, that's just as difficult. What is the defect of the product other than a fault committed by the laboratory? It's the same thing. It's very difficult to analyze the adverse effects of a product when it's on the market. So it doesn't simplify things. This is not something that protects. It simply gives kind of a smokescreen of protection. We have this idea now that don't do your trial alone. If you're all together, it'll be easier. But if you all fail, you'll fail together. So this class action that worries the healthcare professionals was not even requested by the victims, and you won't use it for the victims then? Well, in French law, it makes me laugh when there are legislative modifications such as these. Under French law, we've already been using class action. I've been defending the victims of Distilben in a class, in a group. With Mediator, we had 100 and 150 victims together in front of the courts of Nanterre. Lawyers know how to do this. The law already allows us to do this. So this new style of class action has been voted by the legislator. How is it going to be organized? Is it useful to consider that the victims must go or work via an association? Is it important to let these associations fight each other to understand who will be the spokespeople? Should it be an association that receives an approval, a national approval, that will be able to defend the victims of drugs to the detriment of other victims associations who are better informed? So you started talking, have you had discussions with these different associations about working together? Because you will have to work together if you or your colleagues use this new instrument. Do you think these associations are well equipped? And it also means you'll have to share the income linked to these trials or the revenue. Well, this may not please people, but I'm a victim's lawyer, and a victim's lawyer is a defense lawyer. So what I'm really interested in is to ensure that the victim finds either an amicable settlement or a legal solution for reparations for the damage. I don't consider this redress if it's defended by an association. The association has its own interests that are not always aligned with the victim's interests that they're supposed to be protecting. So you see in the future certain associations will launch class actions to create their own advertising or their own buzz. Yes, or maybe even their own business, because we're talking about business at this conference. So that is a possibility, you think? Is a question of visibility for the associations? Yes, it's a possibility for them to enter a field that was not their field, and it's not adapted to the healthcare sector. I don't have a problem if an association wants to federate interests when it involves a car, a defect in a car, or a can of Coca-Cola that might explode. That doesn't bother me because this is just pure consumption. In terms of individual redress, this is intimate. This is people's private health, it's emotional, it's much more technical to judge, and it has consequences that are much more important for the person who's taken it before the courts. So I believe that there's a lot of work to be done on each case, and it's not necessarily the victim doesn't want to have just a number on their case file. They want to be heard as an individual victim, and I agree with what Mr. Durand said. We're trying to ensure that victims feel comfortable when they don't have a lawyer. Whether it can be a lawyer, a doctor, or an association, but each person has their role. The Commission doesn't need to feel empathy for the victim. The victim is looking for redress, and the lawyer working with the victim defends. He highlights the damages and looks for responsibility. So we're going to have to conclude on the topic, but just perhaps, Mr. Rance, you have another view of this new legal instrument? Well, I think we're looking for ways to treat these serial damages, and indeed there was a demand on the part of the associations of victims. They had the feeling that people were alone in their battles against these huge machines, large law firms defending large pharmaceutical firms. And so this is why they felt there was a necessity to have these class actions. And yes, the drawback may be the duration, as Madame Verdier just recalled. There will be a first phase when they look for liability and then the individual damages, and it may take longer. So, however, we have developed, the legislator has developed at ONIAM, there's an independent college. Ever since the Mediator scandal, we have an amicable settlement process to treat these serial damages, which has proven its worth, linked to this specific product, Mediator. But it's a very specific college, but maybe that could be extended. It could be a good use, a good instrument. But just to say that we have already processed 7,000 case files out of a larger number. And this should be finished before the end of the actual Mediator trial. So that reassuring statistics in terms of results obtained does reassure us. And we'll see what this class action gives in next year when we're back at CHAM. We'll discuss it again. Thank you all for your participation. Thank you. Thank you so much.